Hello again. I'm hoping that you've been thinking about Professor Menkle Meadows' short argument that we addressed a while ago. And I hope you've been trying to work out what Menkle Meadow is arguing in that short paragraph, and also whether or not Professor Menkle Meadow and Lord Bingham would perhaps agree on certain points. Well, I think what Menkle Meadow is arguing about is that in what she calls a deeply divided plural world, we're not going to agree on what she calls substantive goods. In other words, key things that we all agree upon. The best that we can perhaps hope for are procedures which, if you like, treat us fairly. This is the point of commonality, if you like. This is the key thing that we can ask of the institutions which, if you like, govern us, so courts, if you want to include that in this argument. I think that what Professor Menkle Meadow is talking about is broadly in agreement with what Lord Bingham is talking about. If you remember, Lord Bingham's argument was about those legal principles that constitute fairness. In other words, I think we can put these two arguments together. Menkle Meadow's broader account of, if you like, letting the other side be heard, the audi alteram partem principle, as the guiding principle that should underlie common institutions that define our societies, if you like, our political communities, that this idea of what is common principle, that both sides of an argument should be heard, is linked to those principles of fairness that Lord Bingham talks about. For instance, the idea of the neutral judge, the idea that a party should be able to scrutinise evidence against them. All of these arguments, to me, add up to a much broader argument about the fairness of law. And I think if we're thinking generally about the values of the common law, the idea of fairness is an important one to hang on to.